Marbury established the doctrine of judicial review, meaning that the Supreme Court has the power to declare a legislative or executive act in violation of the Constitution. The court also confirmed the Constitution as the paramount law of the land when it is in conflict with an ordinary law. Here, the Supreme Court confirmed the Supremacy Clause, Article 6. As a result, Marbury defined the role of the Supreme Court, which under Article 3 of the Constitution had remained vague. For the past 220 years, judicial precedent has been established through the Supreme Court's interpretation of the Constitution as final arbiter in the court of last resort. In the end, Marshall bridged a fine line of expanding the judicial power while avoiding a constitutional crisis. Controversy. There remains some controversy among constitutionalists concerning this decision. All seem to agree with the court's interpretation of the Supremacy Clause. However, the debate is over judicial review since the Constitution is silent, with a lack of any textual reference on the power. The strict constructionists argue that Congress has as much right to final review as does the judiciary, which raises the question whether the decision is legitimate and permissible on the merits. Does the court have a legitimate right to judicial review, or did Marshall grab power for the judiciary? Though the framers were well aware of the issue and understood it, they failed to explicitly include judicial review within Article 3 of the Constitution, which is perhaps a more puzzling question. Why not include it? Going back to the Constitutional Convention of 1787, there had been strong support for judicial review. Alexander Hamilton, in Federalist Paper number 78, writes, "Complete independence of the courts of justice is essential in a limited constitution. By a limited constitution, I understand one which contains certain specified exceptions to the legislative authority. Some perplexity respecting the rights of the courts to pronounce legislative acts void has arisen from an imagination that the doctrine would imply a superiority of the judiciary to the highest legislative power. It is far more rational to suppose that the courts were designed to be an intermediate body between the people and the legislature in order to keep the latter within the limits assigned to their authority. The interpretation of the laws is the proper and peculiar province of the courts." This excerpt indicates intent not only appears sufficiently clear and is echoed in Marshall's written opinion, but demonstrates that judicial review was a mature theory contemplated by the framers. In addition, judicial review was used previously by the Virginia High Court to reject a Virginia statute in 1796. The point being that judicial review was far from a new concept devised by Marshall. Procedurally, Marbury filed a petition for the issuance of a writ of mandamus in the Supreme Court under the Judiciary Act of 1789. His suit was filed against Secretary of State Madison, demanding the delivery of a commission appointing him Justice of the Peace in the District of Columbia by outgoing President John Adams. Mandamus in Latin means we command. The third party plural of the infinitive verb mandare, to command or to order. A writ is a written command issued by the court. Procedurally, this is important. Marbury filed suit directly in the Supreme Court rather than a lower federal or state court. And this is where the conflict between the Constitution and the Judiciary Act occurs in the Supreme Court's judicial power to entertain the case. Marshall used the lever of jurisdiction to simultaneously restrict the court's jurisdiction while expanding its power of judicial review. A clever and well-executed legal decision. The Judiciary Act granted the Supreme Court authority to issue writs of mandamus to any court appointed or person holding office under authority of the United States. Marbury took the quickest and most direct route available in an attempt to secure a remedy at law. An interested onlooker at the time would have likely concluded that Marshall would grant the writ, forcing delivery of the commission to Marbury. End of case. And no one would have heard of the likes of the lower-level Federalist crony, William Marbury. But of course, that's not what occurred. And instead, Marbury has gone on to live in infamy. William Marbury's attorney might have thought that this was going to be an open and shut case. And why not? After all, Judge Marshall, a staunch Federalist, was President Adams's Secretary of State, who Adams had nominated as Chief Justice of the Supreme Court. Marshall served as Secretary of State until the end of President Adams' term, and amazingly, Judge Marshall was the same guy who affixed the seal to Marbury's commission. It gets better, though. After Jefferson's inauguration on March 4th, 1801, Marshall stayed on briefly as Secretary of State to help with the transition, I suppose. So here we have both Marshall and Madison who failed to deliver the mandamus. I wonder what Marbury's thinking at this point. Maybe he's starting to have some doubts. I mean, these facts involving the Chief Justice of the Supreme Court are pretty crazy. I'm not going to get into the conflict issue here, but Marshall still had work to do. That was namely beefing up a weak Supreme Court by bringing it up to par with the other branches. And that's what he did with judicial review, and the decision I'll get into in a little bit. In the end, Federalist soldier Marbury was forced to take one for the team, as his case was dismissed for a lack of jurisdiction, but things didn't end too badly for Marbury. The case was dismissed without prejudice, so Marbury could still file on another court to hear his claim, and I think he eventually did receive his commission. The Articles of Confederation, 1781, was the nation's first government charter. The Union was weak and the states remained self-interested. If left to its current course, the states would have veered off unto their own devices. This might have resulted in regional confederacies or independent states. Who knows? What we do know is that the United States had little significance, meaning, or power, and the great nations of Europe had taken notice. A constitutional convention was called in May 1787 to address the problems. A new constitution was drafted and ratified by the states upon the premise of limited and restricted federal power, a fear so prevalent in the American mind of the day that it required memorialization in a separate amendment. The 10th Amendment reads, "The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people." Fresh in the minds of Americans was the long and bloody Revolution. America survived while maintaining many of her former institutions and way of life. The new nation had a sound foundation, unlike the French Revolution, in which the French people devolved into bloody massacre and debauchery. Americans needed a guarantee that the federal government would not become the corrupt, tyrannical body as they perceived in Parliament. This led the framers to construct a new system of government called federalism, where both federal and state governments coexist in shared and divided power, with the federal power being limited and enumerated. "The only chance we have to support a general government is to graft it onto the state governments," said one delegate at the Constitutional Convention. The primary characteristic of the American system was that of shared sovereignty. This was how Madison, the central architect of the Constitution, viewed power. It was unique when compared with Republican governments of the past, since the Constitution provided for a diffusion of sovereignty as opposed to a single sovereign. Power administered in this manner was blurred and dependent upon debate and compromise for resolution. It was this inability to debate and compromise in the middle of the 19th century which caused the system to seize, followed by 4 years of civil war. The court found that Marbury was entitled to the Justice of the Peace Commission since it was a vested property right. Marshall wrote, "When the seal is affixed, the appointment is made, and the commission is valid. It is a plain violation of that right for which the laws of this country afford him a remedy." So failure to deliver was solely a technical matter. Next, the inquiry turned to the nature of the writ applied and the power of the court. Marshall distinguished between the court's power to hear cases. That power comes in two forms. One is through original jurisdiction and the other is appellate. Recall that Marbury filed directly in the Supreme Court under Section 13 of the Judiciary Act, thereby creating the case in the Supreme Court. Article 3 of the Constitution, however, grants original jurisdiction sparingly. in cases affecting ambassadors, other public ministers and consuls, and those in which a state shall be a party. Marbury's request for a writ of mandamus is not provided for. The court lacks authority to grant Marbury's petition for the writ since it is not warranted by the Constitution. In all other cases, the court shall have appellate jurisdiction. The essential criterion of appellate jurisdiction is that the Supreme Court, Marshall said, revises and corrects the proceedings in a cause already instituted and does not create the case. Marbury fails there as well. It's now obvious that a conflict arose between the Judiciary Act and Constitution. In such a situation, the Constitution must prevail. Marshall argued that constitutions, by their very nature, are fundamental and paramount law of the land. This is self-evident, since that's the very reason they exist in the first place. Asserting the claim that constitutions are fundamental and paramount law is the same type of statement as all triangles have three sides and all bachelors are unmarried men. They are analytic, meaning that the predicate is already thought in the subject, and to say otherwise is a contradiction. And constitutions must be treated as such, or they shall become nothing more than hollow historical documents. Marshall wrote, quote, "It is emphatically the province and duty of the judicial department to say what the law is. If two rules of law conflict, the court must determine which of these conflicting rules governs the case. This is the very essence of judicial review. To do otherwise would be giving the legislature a practical and real omnipotence with the same breath which professes to restrict their powers within narrow limits." Closed quote. According to Marshall, the court is best positioned to make this determination to avoid the self-interest of Congress, who may be tempted to favor their own legislation, and by doing so would cheapen the Constitution. It was through this decision that the Supreme Court gained new relevance. Keep in mind that this case deals with federal law. Subsequent cases, as Martin v. Hunter's Lessee, 1816, is where the court addressed judicial review over state decisions. And finally, the Federalist Party of Washington, Adams, Hamilton, Marshall, and Marbury, following the inauguration of Jefferson in 1800, continued to lose ground to the Democratic Republicans, whose major theme was one of limited government. The Republicans gained in popularity as their policies resonated with the shifting attitudes of an expanding population. Republicans professed the ideals of the Revolution that they claimed the Federalists had abandoned. In the end, the Gentleman Party lost touch with the average Nathaniel, who turned their backs on the paternalistic gentry of self-proclaimed great men. By 1814, the Federalists were a dead political party.